introduce myself. My name is Matthew Eaton Kent. I'm a criminal defense lawyer and child protection lawyer. I've been practicing for 10 years. I also work on a judicial reform project that aims to reduce criminal justice charges for youth that are in the child welfare sphere. So I have experience representing young people before the criminal justice system, particularly ones who are vulnerable, ones who have been taken from their family by the courts due to their treatment at the hands of their family and caregivers. I also have experience representing Indigenous Canadians before the criminal justice system. Um, People who have mental health issues, who are found not criminally responsible before various review boards in Canada. And I also sometimes represent victims of sexual assault in records applications before the criminal justice field. So I do a variety of law, and I'm here to share my expertise and experience on youth and juveniles who are before the Canadian criminal justice system. So the Canadian criminal justice system is for youth is governed by the Youth Criminal Justice Act. That is a companion piece of legislation that is a companion of the criminal code in Canada. So the federal government in Canada is responsible for criminal law, and there is a code of conduct in Canadian law that governs how what is criminal conduct, what's illegal to do under the criminal code, and how those procedures are to move through the courts. And the Youth Criminal Justice Act, it takes a lot of, or the criminal code still applies to youth. But then there's a piece of legislation on top of it that governs specifically and specially how youth are to be treated before the criminal court. So there are various jurisdictional issues, various other particular protections within the Youth Criminal Justice Act that make it the way that a youth would move through the criminal justice system very specialized to anyone under between the ages of 12 and 18, one day less than 18. If you're under 12 years old in Canada, you can't be charged with a crime. So there is no criminal law that applies to anyone under the age of 12. And if you're 18 and above, then it would be the criminal code that would apply, and none of the protections found or the rights or the procedures found in the Youth Criminal Justice Act would apply to you. So what makes the Youth Criminal Justice Act particularly unique is that there is a preamble at the start of it, which it's sort of several guiding principles of how the act should be interpreted. And those are applied throughout the Youth Criminal Justice Act, and they're a method for how to interpret the other sections found within it. So the first most important principle in the Youth Criminal Justice Act is that there's a recognition that young people's brains are not fully developed, particularly the part of the brain that in regards to decision making, in regard to impulse control, and therefore there's a diminished moral responsibility for that young person when they have broken the criminal law in Canada, or are alleged to have broken the criminal law in Canada. So like most criminal law in Canada, it's about personal responsibility and potentially personal consequences to the person who is alleged to have broken criminal law. And so there's a distinguishing feature within the law that says for young people, the consequences are not going to be as severe as they would be if you were an adult. And if you did break the law, your moral responsibility is lower. The amount that you're responsible for that, because we understand through science that the way that you make decisions is not as fully formed when you're under 18. There's been some emerging science that has shown that maybe it's not quite a hard cutoff at 18, that can go up to 25. But so far, our law is there's a strict 18 cutoff. There is some recognition in adult criminal law of what we call youthful offenders, but they don't get the same kind of protections as you do as a classified youth under the Youth Criminal Justice Act. The other parts of the preamble are that the legislation should be interpreted in a holistic manner, that there are that we should be looking at the root causes of youth offending behavior, and that we should take a multidisciplinary approach to how to address that. So that means that this is not just a criminal law or court-centered way to deal with it, that the court should be, and the justice system should be, broadening the lens to include education, social workers, diversion programs, counseling, and even potentially, trying to, in some circumstances, address some of the economic and social issues that are causing the young people to end up before the court with charges and offending behavior. And so that can include even, referrals to social programs and wealth transfers and that kind of thing. Obviously, you don't have courts ordering money to be sent directly to the parents of people who are offending, but they can be connected to services that help to address the issues that are going on with the youth. So again, it's a way of looking at it in a broader lens than just the personal responsibility of the youth, and how that is applied and what programs are created because of this, guiding principle is up for interpretation, and there's various things that we'll discuss in Canadian law, but that's just a guiding principle that helps you to know that there needs to be sort of a different approach than strictly, the person who is alleged to have committed the offense goes in front of the court and you either prove it or you don't, and then they have consequences or there aren't. There's also the UN Charter on the Rights of Children, the Canadian Charter of Rights and Freedoms. Those are also guiding principles that are written right into the preamble, that those are tools to help you to interpret what's in the rest of the legislation. The Youth Criminal Justice Act was passed in 2002 in Canada, and that was in response to legislation that existed before that that had resulted in a very disproportionate number of young people ending up in custody and jail. And that was something that the Parliament wanted to change. And so the Youth Criminal Justice Act was passed into law, and the direct purpose of it was to address that very high rate of incarceration for young people. I think there's a recognition that jail has a traumatizing effect on the young person, and that anything should be done, if it's reasonably possible, to avoid a young person either spending time in pretrial custody or sentenced to custody. And so that's what some of these guiding principles are about, is can we, make amends? Can we deter, denounce the conduct while still having sentences that won't traumatize the youth? So there is a prioritization of rehabilitation for youth right in the law, and particularly even though it's recognized that there can be some um, uh, rehabilitative components to being in jail within the law, whether that's borne out in reality, I'm not sure, but certainly the Youth Criminal Justice Act prioritizes rehabilitation if the person was convicted, or even um, you know whether they agree or not, but they're charged, and their youth is not fighting the charge. It's you prioritize rehabilitation within Canadian law.